Good morning, everyone. This is Kate Burdick from Juvenile Law Center, which is also part of the collaborative known as the Legal Center for Youth Justice and Education. And I'm here today to talk with you about what the Every Student Succeeds Act means for youth who are involved in the juvenile justice system. And in doing so, I'm going to focus on the amendments to Title I, Part D of that law. Thanks for joining us. So just to get started really quick, Juvenile Law Center is a nonprofit law firm located in Philadelphia, but we work nationally. And our mission is to ensure that students who are in the juvenile justice system, the foster care system, or young people who are in the adult criminal justice system have access to fair treatment while they're in those systems and have access to opportunities that will help them prepare to become successful adults. Obviously, education is a huge part of that, and that is what I focus my work on. And this past year, we launched a Legal Center for Youth Justice and Education with our partners at Southern Poverty Law Center, we're Juvenile Law Center, Education Law Center of Pennsylvania, and the American Bar Association Center on Children and the Law. And the mission of that particular center is to ensure that all children in the juvenile and criminal justice systems can access their right to a quality education. It's based on a similar collaboration we have called the Legal Center for Foster Care and Education. So I'm really pleased to be speaking with you today about this issue, and in particular to be focusing in on students with disabilities, because unfortunately students with disabilities are entering the juvenile justice system at a rate 5 times higher than youth who are in the general population. So it's really important that disability rights advocates are aware of the particular education rights pertaining to youth in the juvenile justice system because of that huge overlap. And just to underscore that, children in the juvenile justice system are really behind academically, chronically behind in school, and there are studies that estimate as high as 77.5% of them are eligible for special education services. Another statistic says that nearly 4 times as many youth in correctional facilities are eligible for special education compared to the national average of students with disabilities. And overall, these are students who are very behind in school, and you can see here both state and local juvenile justice facilities. One of the biggest problems that we see with education for young people involved in the juvenile justice system relates to re-entering school after being placed in a juvenile justice facility. And I'm going to talk a little bit more about that as we go, but I just wanted to highlight that unfortunately 2 out of 3 students coming back from the juvenile justice system drop out of school. That's a really sobering statistic that we're working to change, and we're hopeful that these changes to Title I, Part D of the Every Student Succeeds Act help with, but it's an unfortunate reality we're working with right now. Juvenile Law Center has a youth engagement program called Juveniles for Justice that consists of young people who are currently or formerly involved in the justice system in some way and want to learn to advocate for change in that system. And last year, they made this guide, Justice for Juveniles, Youth Recommendations to Improve Educational Outcomes for Youth in the Juvenile Justice System, with their recommendations and personal experiences related to education access for young people in the juvenile justice system. And I just wanted to highlight a couple of quotations from there because I think it really drives home the point of why it's so frustrating for these young people to get the access to the education they're entitled to while they're involved in the system, and why so many young people drop out. So one young woman said, "When I left a juvenile justice facility and returned home, I was only 1 credit away from graduating. Unfortunately, my public school said that they would not accept my credits and that I would have to go back to 9th grade or take GED classes." And so that young woman actually did go on to take GED classes, but a lot of young people just drop out entirely and don't even go on to get their GED. Another student said, after I left my placement, I tried to re-enroll in my community school, but I was told that I would be denied entry because I had been truant. And so she actually had to go to truancy court because her placement in the juvenile justice system wasn't communicating with her school at all. So these are just two examples of the myriad problems with education access that these young people have to endure. So the Every Student Succeeds Act, and specifically Title I Part D, does provide some strengthened language around access to education for young people who are involved in facilities, and specifically, I think, really focusing on reentry. And I have here for you a fact sheet that explains this that we put together with some of our partners, and I think will be a helpful kind of overview for you if you want to remind yourself of these provisions after the fact. So I included the link there and encourage you to check that out. And that will kind of mirror a lot of what I'm walking through today on this webinar. I also wanted to make sure that you are aware of the Title I Part D National Assistance Center, NDTAC for short, which has the website here. And they have a ton of information, both related to Title I Part D specifically, but also other resources related to children and youth in the juvenile justice system. So Title I Part D has three broad goals. The first is to improve educational services in local, tribal, or state institutions for neglected and delinquent children and youth in order to provide opportunities to meet state academic standards. The second is to improve youth transition between institutions to further schooling or employment. And the third is to prevent dropout of youth and to provide young people returning from correctional facilities or institutions for neglected children and youth with reentry support to ensure their continued education and the involvement of their families and communities. And Title I Part D has two subparts. So just going back to the previous slide, we noted subpart 1 and subpart 2 and how many students with disabilities those subparts serve. And in subpart 1, state educational agencies receive funds through the formula, which is then they're able to subgrant to state agencies serving neglected or delinquent youth. And in subpart 2, SEAs award funds to local educational agencies in the state with high numbers of children and youth in locally operated juvenile correctional facilities. And I will say that right now every state and DC and Puerto Rico receive Title I Part D funding in some way, and the funding actually reaches hundreds of thousands of young people through the programming it supports. So it's not that small a program. Definitely these changes are a big deal. So what are the changes to Title I Part D that are relevant and that we think are good on the whole? So first of all, state agencies have to establish procedures for youth to be assessed to identify educational needs when they enter a juvenile justice facility. There is a caveat there that says when practicable, that we're hoping that guidance will clarify what that really means. But this is an important addition because while previously there were provisions encouraging the assessment of the educational needs of youth, it didn't specify that that assessment should be done when the youth enters the juvenile justice facility. And as I'm sure you are all aware, identifying those education needs as soon as possible is going to be better for the youth, so that if the child needs to be referred for special education services or have some other kind of intervention put into place, or they previously were identified for special education services but the IEP services are not actually meeting their needs and allowing them to make progress, then that really should be nipped in the bud and addressed as soon as possible. And especially if the student is going to be in placement for a while, it can actually be an opportunity for them, contrary to what usually happens, an opportunity for them to improve in their education and get back on track by getting those services if their needs are properly assessed from the start. Another big issue that we hear a lot of complaints about from folks around the country is related to the lack of records transfer between local educational agencies, homeschool districts, and then those correctional facilities. So both when youth are coming into the facilities not getting access to full records for the young person, and then of course when the young person is trying to return to their community school or go on to another program, that their records aren't transferring with them. And I'm sure, as you can imagine, if you haven't experienced directly, this creates a host of problems where for example, their IEP isn't being transferred, so the new school doesn't know they have an IEP, or that an evaluation is in progress, or that they're in X grade, or that they've earned such and such number of credits, or who their educational decision maker or surrogate parent or other parent involved in their education is. So it's really important that that process gets streamlined, and the changes to Title I Part D that came in under ESSA do try to emphasize the need for records transfer. So specifically, correctional facilities must work with the youth's family and the local educational agency to ensure academic records and plans regarding the continuation of educational services for youth are shared and transferred with the youth from the facility back to the local educational agency or the alternative educational program that they're going to next. So that's, I think, a critically important update to the law. Let's see here, moving on to the next one. So reentry planning is a hugely important part of making sure that the child successfully reenters school upon leaving a correctional facility. And you may have heard the phrase, think exit at entry. That's really getting at this point that as soon as the child matriculates to, or whatever phrase you want to use, to this correctional facility, that reentry planning needs to begin. And the programs that are doing this particularly well usually have an assigned transition coordinator and who are working with the home school district, with the youth themselves, of course, and with the youth's family and communities to try to think about from the start what's the long-term plan educationally for this young person, so that as soon as we get the discharge date, they are able to return to the community. So Title I Part D also recognizes this and encourages correctional facilities to work with LEAs to coordinate educational services so as to minimize disruption to a youth's education when he or she exits the facility. And keep moving here. I mentioned before credit transfer. This is a huge one, and it really goes back to those quotes that I brought up at the beginning of the presentation, where a young person oftentimes will find when they leave a correctional facility that their credits didn't transfer. Either they weren't actually earning credits, or the credits that they did earn aren't being recognized by the school district that they're going back to for whatever reason, perhaps because they have too many electives and they don't need that many electives. What they really needed was a substantive math course in order to graduate on time, or because the school district doesn't think that the credits earned in the correctional facility are actually valid. And then, of course, records getting lost is another problem. So it's not uncommon to hear stories of young people who thought they were in 12th grade, and then it turned out they're being told they need to be in 9th grade or 10th grade. And this can be extremely frustrating, and oftentimes then can lead to the young person to say, I'm not going back to 9th grade or 10th grade where I already took these courses and all the students are younger than I am. I'm just going to drop out of school. So anything that we can get into law that really makes the transfer of credits smoother is critically important. And so the Title I Part D changes do say that state educational agencies must ensure timely transfer of credits earned in juvenile justice placements. So that's a huge step forward on that point. Another issue is what happens when the young person leaves the facility and where are they going to go to school next. So usually what we want is for them to go back to the home school that they came from or another school that best meets their needs. But in practice what may happen is that the young person is denied enrollment either on a technicality or for some other reason, and they're kept out of school altogether for some period of time. It can also be that they are shunted to an alternative school. In Pennsylvania, we call them alternative education for disruptive youth. They're not supposed to be automatically sent there, but unfortunately they sometimes are. And I know that that is an issue around the country where young people who are coming back from placement are just sort of being put into these dumping ground schools where their needs are not necessarily being met. And so one of the pieces of Title I Part D that I was excited about is that state educational agencies have to ensure procedures to ensure youth leaving correctional facilities are timely re-enrolled in the school or program that best meets the student's needs. Now, there are portions of the law that do leave open the possibility that the student will go to an alternative educational program. But I think it's really important that the language that best meets the student's needs is in there so that it's not an automatic decision, not something where we're just discriminating against all students returning from juvenile justice placements, assuming that they're bad kids or don't want to learn or something like that, and sticking them in schools that won't allow them to progress. So I think the language about best meeting the student's needs is really important there. And LEAs are also required under the law to offer programs to facilitate transition for youth who are reentering. And of course, we want young people to have access to quality educational opportunities once they are back in and have made that return. So under the law, SEAs have to provide opportunities for youth to participate in credit-bearing coursework once they are back in the community. So that's very important. And then there is also a provision of the law that says as appropriate, so there is that little caveat there, but as appropriate, local agencies should forge partnerships with higher education or businesses to facilitate post-secondary and workforce success. And that's really important because we see that the places that have made connections with their local community colleges or their Chamber of Commerce or other business communities around them have been able to provide really high quality learning experiences that not only keep youth actually progressing in their education, but make it relevant, help engage them in school, and keep them from dropping out. Another point that is really exciting about the Title I Part D changes is the emphasis on a regular high school diploma. And this is a big deal because a lot of places kind of assume that just because a youth is maybe overage and undercredited, or just because they're involved in the juvenile justice system, that necessarily a GED or other high school equivalency is going to be the best bet for them, and they're never going to get enough credits, or they're never going to be able to obtain their high school diploma. And although the research says that a GED is certainly better than not having any high school equivalency, there is research to support the fact that students who do have regular high school diplomas earn more and do better in the long run than students who just have a GED. So we don't want to be underselling these kids and assuming that we should just stick them in a GED program without taking a look at their individual situation. And so under the law, SEAs and correctional facilities have to assist the youth in obtaining a traditional high school diploma. There is also an accountability measure for LEAs under the law where they're actually measuring how many students attain a regular high school diploma. And state and local jurisdictions are also required in the reporting part of the law to track the number of youth who graduate on time as kind of a related issue to that. So again, just some good emphasis with the new language under these amendments. There are some additional changes to the law that I won't really go into great detail on, but are just sort of good to know about. There's a little bit of increased language about family involvement. I wish there were even more, but of course we want families to be involved, and students do best usually when their families or communities are involved and continuing to be a part of their education. So there's some language in the law around that. In addition, there is some language in the law where ESSA expands the purpose of Title I Part D to improve educational services for youth in tribal institutions for neglected and delinquent children and youth. And state agencies under the law should utilize their funding on transition services for youth moving between institutions and schools operated or funded by the Bureau of Indian Education. LEAs similarly can use Title I Part D funding for programs supporting, quote, at-risk Indian children and youth, including those who are in correctional facilities operated by the Secretary of the Interior or Indian tribes. Another point of note is that state agencies seeking funding under Title I Part D have to note, to the extent feasible now, but still have to note when a young person has come into contact with both the child welfare and juvenile justice systems. It does not define contact, so that's something we're hoping guidance or regulations might spell out, like whether the child has to actually have been adjudicated in both systems, or one contact, one call is enough, or what that really means. But we think that's important for kind of tracking the high number of youth who do tend to be involved in both of those systems, juvenile justice and child welfare. And in addition, states are now explicitly allowed to use their Title I Part D funding to provide targeted services for youth who have come into contact with child welfare and juvenile justice. And finally, the definition of at-risk youth under Title I Part D was expanded to include youth who are at risk of being adjudicated dependent or delinquent, as well as youth who have had any contact with the child welfare system. I also just wanted to kind of bring up the fact that even though today we're talking about Title I Part D, and this is part of a series of webinars focused on ESSA, and in particular ESSA, what it means for different vulnerable populations of young people, that of course there are many other laws in effect. The IDEA, Section 504, ADA are some examples, in addition to state laws and regulations. And so advocates working to improve education access for young people in the juvenile justice system should, while it's good to be aware of Title I Part D, there are these other laws that already existed that are very strong and should be utilized. And one issue brief I wanted to particularly flag is this NDTAC resource on providing FAPE for young people in secure juvenile justice facilities. I encourage you to check that out, as well as the other resources on the NDTAC website. All right, and that's it for today. You should feel free to email me at kburdick@jlc.org if you would like to join our free national listserv related to juvenile justice and education issues. It's a diverse group of stakeholders, and we use it to get out information like this and to share ideas and whatnot. So we'd love to have you on the listserv, or just shoot me an email if you have questions that I can be assistance with, or that I can put you in touch with someone else who might know the answer. So thank you so much for listening in today and for caring about improving educational access for young people in the juvenile justice system. And I hope you have a wonderful day.
Thank you. Please stand by.